her life is on the line. Karen Reed, the future of her life is on the line if they don't get this right. After 8 weeks of contentious trial that saw the testimony of more than 70 witnesses and dozens of exhibits, the fate of Karen Reed is now in the hands of a Massachusetts jury for her role in the death of Boston police officer John O'Keefe. Plus, 11th hour legal wrangling as Alec Baldwin's manslaughter trial for the on-set shooting of cinematographer Helena Hutchins is set to kick off in a matter of days. All this and more this week on Courtroom Confidential. This is sure to be one of those watershed cases for the year. Everyone seems to have been watching the case of Karen Reed in Canton, Massachusetts, and whether or not she is going to be found guilty for the murder of her boyfriend, Boston police officer John O'Keefe. It's hard to think of another case that didn't involve a celebrity or a sports figure that has really captured this much attention throughout the country. Let's jump right in. As jury deliberations enter their fourth day, very little is known about what jurors may be thinking as they continue to weigh the fate of Karen Reed, who stands accused of killing her boyfriend, Boston police officer John O'Keefe. The prosecution alleges that after the pair spent a night drinking at two separate bars in Canton, Massachusetts, Reed and O'Keefe engaged in a heated argument which ended in Reed backing her SUV into O'Keefe, leaving him to die in a snowbank outside the home of a friend they intended to meet for an after-party. Reed is charged with second-degree murder, manslaughter while operating a motor vehicle under the influence of alcohol, and leaving the scene of an accident resulting in death. At least 250 people were outside the court Tuesday morning when Reed arrived for closing arguments, many of them chanting, "Free Karen Reed." Both sides were given 1 hour to present their closing arguments. If you would like much more in-depth analysis of these closing arguments, please be sure to check out my live reaction video that you can catch right here. You have been lied to in this courtroom, and your job is to make sure you don't ever look the other way, argued defense attorney Alan Jackson. Jackson laid out the alleged cover-up, referencing what he described as destroyed evidence, compromised investigators, and planted evidence. Prosecutor Adam Lally opened his closing argument by quoting witnesses' testimony of what they state Reed said the morning O'Keefe's body was found. "I hit him, I hit him, I hit him, I hit him." Those are the words of the defendant. 4 times, Lally said. Lally asserted that Reed deliberately backed her SUV into O'Keefe, citing their strained relationship and recent arguments as a possible motive. Lally dismissed the defense's cover-up theory, arguing that physical evidence and witness testimony confirmed O'Keefe never entered the house that night. He urged the jury to focus on the forensic findings and the timeline of events to convict Reed. But problems with deliberations began to arise almost immediately. Around 10 a.m. on Wednesday, court reconvened without the jury present, and defense attorney Alan Jackson argued to Judge Clenney that the verdict slip was inappropriate. He took issue with the absence of a box for not guilty. Clenney explained that the slip was a standard verdict form and that this is how things are done. Jackson responded sharply, saying he didn't care how things are done, adding, "This is not how it should be, and it's over our strong objection. They need to see there is a not guilty option," Jackson said. As this exchange was underway, Clenney apparently noticed a reaction from Reed that she didn't appreciate. "Excuse me, this is funny, Miss Reed," Clenney said before announcing, "All right, we're done," and quickly leaving the bench. At a later hearing, Clenney acknowledged Jackson's point that the verdict slip could prove confusing to the jury and said she would clarify the matter with supplemental jury instructions and make some minor changes to the verdict slip. The prosecution did not object to the proposed changes. As of the time of this recording, the jury has had only one question regarding if they could see additional evidence, to which they were given a standard instruction on how they have all the evidence they will ever receive. Since that time, the jury has been completely quiet, causing many observers to run wild with speculation. All right, what's happening here? First question is, and everybody's asking, is this taking too long? Are they deliberating too long? What does this all mean? The answer is no. No, they're not taking too long. This trial was 8 weeks. The jurors have been dealing with this for longer than that because they went through jury selection. This is going to take some time. Usually the rule of thumb is that for every week, you should expect an hour. Now, I realize that as we're having this conversation, they may have gone past that point. But this was a very dense trial. The question before them wasn't simply, did she do this or didn't she? It's also, was there a cover-up involved in all of this? Should we be spending all of this time reading into any of this? Sure, why not? It's fun, right? I mean, that's what this is all about. I will tell you that as a trial attorney, aside from doing trials, the favorite pastime of trial attorneys is trying to speculate about what juries are thinking, trying to read the tea leaves with every single question that comes back from a deliberating jury, or trying to read the tea leaves of no questions coming back from a deliberating jury. It's all about superstitions and what do quick verdicts mean and what do slow verdicts mean and what do a lot of questions mean and what do no questions mean. You will drive yourself nuts, as I have done many, many times in the past over my career. It is a fun yet useless undertaking and enterprise. I will tell you this. They are working. We know that. We know that from the question. They're asking for evidence. They are most likely going through all of it. A quiet jury means that it's a jury without real problems, is one thing I can tell you. If they were coming back already with questions like, what do we do if we're hung? Then we've got some problems. If they're coming back with a question like, what is reasonable doubt? Then we've got some issues. The fact that they're back there and they're quiet is, I think, the most that you can say is that they're thinking and doing their job, and God bless. That's what they should be doing. The only thing I think you could read into any of this is when they've asked to go home at a certain time, which means they're not likely to reach a verdict that day. Doesn't sound like they've reached an impasse. Doesn't sound like they've reached the point where they feel like they can't arrive at a verdict. It sounds like they're working hard toward it. And there's a lot on the line here too. They realize that. There's a man who's dead, a police officer. It is hard, even if a jury is working towards an acquittal. They realize that they may be letting someone walk out the back door as a free person who may have been involved in taking the life of a police officer. That is no small thing to have weighing on their minds and their consciences. They also realize that her life is on the line. Karen Reed, the future of her life is on the line if they don't get this right. So they're doing their job. I don't think, other than having a good time doing it, we're doing ourselves any favors by trying to speculate as to what they're doing or which way they're leaning. Now, as far as the closings went, and again, please check out the video that I did on this. I put a lot of work into that. We watched and went through the entire closing from both sides and really did some analysis on the clever things that I think actually both sides did. But just to give you a quick take on it here, for Alan Jackson, and I've said this before and I'll say it again, in full disclosure, I've known Alan for close to 20 years. I worked with him in the DA's office. I consider the man my mentor in many ways. And I worked with him as a defense attorney when I left the district attorney's office and went into private practice. And saying all of that and trying to put aside my relationship with him, I really feel that he put on a master class here in how to do a closing argument. His opening words were, "Look the other way." You knew his theme within the opening words. Those 4 words he repeated time and again to drive home the point that the defense position is that the prosecution, the Commonwealth, was trying to infantilize the jurors by telling them to look the other way, that they are either too stupid or too innocent as children, that they should have to trouble themselves with all of these little details and simply look the other way and please help us convict Karen Reed. I thought that was an excellent way to establish a theme because it really was about empowering the jury, that they have this higher calling and responsibility to not do that, to stand as this guardian between Karen Reed and the malfeasance, according to the defense, of the prosecution and the investigators in this case. But one thing I did notice was that he never addressed the elements in this case. Now, I'll get into that a little bit more later as to why I think that might have been, but it's surprising when you see a defense attorney in no way address the elements of the crimes charged. And I think part of that was simply that his client didn't do it. I mean, that's his explanation for it, is she didn't do it. I don't need to go into all of the elements and how they fall short and how they have not been proven beyond a reasonable doubt, because she didn't do it. And if she didn't do it, we don't need to talk about it. I think that might have been one reason for it. But he did touch on the idea of moral certainty. And this is the standard for beyond a reasonable doubt in Massachusetts. And that language I've never seen before. In California, we talk about it in the sense of having an abiding conviction. But this use of the term moral certainty makes it sound even stronger in my view. Think about moral certainty, that you should have a moral certainty in the guilt of the defendant before you are able to find them guilty. I don't know if I have a moral certainty about much in this life. And there are those very few things are probably my love for my wife and children. That is a moral certainty. So to use that term that is provided in the law in Massachusetts, he drove home that term at least. Let's talk about Lally for a moment. I don't think he did a bad job. I actually think he did a very admirable job. Now, in juxtaposition to Alan, he's going to have a hard time. Anybody would have a hard time. You have a very dynamic speaker who's very seasoned, and then you have Lally, who just doesn't have that kind of a character for the same sort of dramatics in him. And that's fine. He's a very matter-of-fact type of person. But I felt that he did an admirable job. And by the way, for the prosecutor, you kind of want that. You don't want theatrics out of your prosecutor. You want them to be a just the facts, ma'am type of person. But his beginning words, I felt, were very strong too. I hit him, I hit him, I hit him, I hit him. That is one of the strongest parts of his entire case, and he made sure that he opened with that and told the jurors about that. He then began to address some of the evidence in the case and talked a little bit about how the defense's theory didn't really hold water. He began to meander a little bit. The strength began to wear thin. And towards the end, he did not end with the crescendo that he may have hoped for. But it was better than I was expecting. But again, he didn't address the elements either, which was even more surprising to me, because that's the prosecution's burden, is presenting those elements. In fact, he spent even very little time on the idea that her vehicle hit him. Now, it wasn't that he missed it, but I would have expected more argument to be made about the elements and specifically intent, because I will tell you this, folks, if there's any problem that I feel that the prosecution has had with this case, it's not in overcoming the defense's arguments about a conspiracy and a fraud or a frame job. They addressed that. Now, it's up to you to decide whether or not they addressed it adequately, but they did address it. But as far as her intent, her criminal intent, beyond an accident, beyond only becoming aware of what may have taken place later on, they had the most work to do, I feel, on that idea of intent. And I don't know if they did that. And he certainly didn't seem to address it in his closing arguments. Now, the things that I found most surprising about the way things were done in this courtroom probably contributed a lot to how the closing arguments were conducted. But one, they were limited to 1 hour each. Wow. This was 8 weeks, folks. 70-something witnesses, dense information, forensics and DNA and accident reconstruction and expert witnesses and civilian witnesses and all of this back and forth. And you're going to give them 1 hour to sum that all up? That is quite an undertaking. And of course, you're going to lose out on many of the arguments I'm sure both sides wanted to make. Maybe that's why they were missing some of these things that I'm pointing out. The other thing on this that absolutely terrified me as a defense attorney practicing in California was the idea that the defense goes first. Where I practice, and in most jurisdictions, you have the prosecution has a split argument, essentially. They argue their opening closing, where they essentially lay out their case. The defense then gives their closing, which they can address some of the prosecution's points. And then because they have the burden, the prosecution goes again in what's called rebuttal, where they're limited to what the defense brought up. Here in Massachusetts, the defense goes first. And so therefore, in many ways, he's operating in the dark. Alan was blind as to what the prosecution was going to argue. Now, he's been living with this for 8 weeks and many more months beyond that in preparation for this trial. So I imagine nothing that Lally said entirely took him off guard, but still not being able to respond puts the defense, I think, at a slight and perhaps more disadvantage. And then the prosecution is just able to answer every question that the defense posed. But again, they're limited to 1 hour. But what do you folks think? I mean, I'm far more concerned with your opinions than I am with my own. Do you think these closing arguments were done well? Do you think Alan carried the day or that Lally carried the day? Please let us know in the comments. All right, moving on. In one last desperate attempt to have the involuntary manslaughter charges against him dismissed, attorneys for Alec Baldwin argued in a new court hearing on Monday that prosecutors withheld evidence showing the gun involved in the incident was damaged. During a virtual court hearing, Baldwin's lawyers explained that the Colt .45 revolver, which fired during a rehearsal for the Western film Rust, killing cinematographer Helena Hutchins, was, quote, destroyed during FBI testing in 2022. An examiner reportedly struck the firearm with a mallet, breaking it into pieces. They understood that this was potentially exculpatory evidence and they destroyed it anyway, Baldwin's attorney John Bash said. It's outrageous and it requires dismissal. Bash and his team have long maintained that the gun fired due to a mechanical issue. You'll remember Baldwin had famously denied pulling the trigger during an ABC News interview with George Stephanopoulos. Prosecutors on Monday countered that the gun's exculpatory value, quote, in the condition it was on October 21st, 2021, is extremely low. The judge said she would issue her ruling today, Friday, June 28th. If the charges are not dismissed, Baldwin will head to trial on July 10th. What's happening here? The gun was destroyed, if you want to call it destroyed, in an attempt to test whether or not it could be fired without the trigger being pulled. This whole case for the prosecution seems to have come down to whether or not he pulled the trigger. And to some extent, I understand why they are drawing that line there. And to another extent, I really don't. They're saying, and I guess this makes sense, that if he's holding the gun and he no way pulled the trigger, then we can't hold him responsible because then that's a malfunction of the gun. Okay, that makes sense to me. I think it would be a bigger deal if Baldwin was saying he didn't even have his finger on the trigger, but they're saying, okay, we have to show that this gun could not be fired without that trigger being pulled. And he's saying he never pulled that trigger. So let's eliminate the idea that there's a possible way that gun can be fired without the trigger being pulled. And the only way they can do that is to test it. And the investigator that they had testing it, the specialist who was administering the test, found that the only way you could get that gun to fire without pulling the trigger was by shocking it in some incredible way. And I imagine this was to simulate perhaps dropping it or banging it against a wall. And they did this by hitting it with a mallet. And in fact, it did fire. That was the only way it would fire without the trigger being pulled. But in hitting it with the mallet, they damaged the weapon. Now, is this a problem? Yeah, it's a problem for a few reasons. One, the prosecution, and by extension, the entire investigating team for the prosecution, are considered the custodians of the evidence in many ways. They're the stewards of the evidence. They should be protecting this evidence, not just for the simple fact of making sure that they can present it at trial, but making sure that it's preserved for the defense to be able to test some of these items. You see this many times when they're doing DNA testing. They have to make sure that if they're going to test something, they preserve some of that material, blood, other bodily fluid in some sort of way that it can also be independently tested by the defense. And that similar argument is being made here, that in not preserving that weapon as it was that day, the defense cannot test it with their own experts to give conflicting testimony at trial. And therefore, they're put at a disadvantage. And that's basically the basis of why they're asking for the judge to throw this out. Is the judge going to throw it out? No. Will they be able to present at trial the idea that the gun was destroyed during testing and prevented the defense from testing it? Sure. Is that going to be enough for the defense? Probably not. And they're probably still going to be upset about it, but they can make those arguments. And I think at the end of the day, the judge is making the right call, if that is the call that the judge makes. But the problem is more for the jury than for the judge, because they're the ones who are going to have to decide this as to what value or what weight to give to this issue. The judge, I think, can just say, it's a question for the jury. I'm not going to prevent this from going to trial based upon that issue. Let the jury decide. And then it's the jury's problem. Is that a big enough issue to them? Are they going to be able to rely upon only the prosecution's expert witnesses enough to say that they believe that weapon could not be fired without the trigger being pulled, except in this one extreme scenario where it's being hit with a mallet? The other issue that we're going to see come up in this case that's kind of unique is the idea of, will Hannah Gutierrez Reed, who was the armorer, who you remember was already convicted for this, will she take the stand, and will she be granted immunity to testify? And the judge answered that by saying, no, she will not. Now, you've heard this reported, perhaps or not, and it may sound like the prosecution was trying to get her to testify against Baldwin. And in order to get her to do that, they had to deal with her Fifth Amendment issues, because she doesn't have to testify because she's got an appeal pending and she can say, I have a Fifth Amendment right not to testify. And in order to get around that, they were going to grant her immunity. What was really going on here, though, was the defense wanted her to be declared unavailable to testify at trial because she had a Fifth Amendment right. And if she is therefore, quote unquote, unavailable, the defense can use prior statements of her without her testifying live in court, use those prior statements at trial. And those prior statements that she made to investigators are helpful to Baldwin. And the prosecution said, no, we see this kind of 3D chess that you're trying to pull here. So in order to make sure that she is not, quote unquote, unavailable for trial, we're going to grant her immunity, meaning she is available. And if you do want her to testify, well, then you're going to have to do that with her on the actual stand. And that probably won't prove to be as helpful to you. So now we're at this weird impasse where the defense could call her and she's not going to be granted immunity. And it's up to her whether or not she decides to testify, which will be strange. I don't think she will testify, but some have pointed out that according to some recordings that she made while speaking to people in jail, she has said that she wants to see Baldwin in jail. Will that be enough for her to waive her Fifth Amendment privilege? We shall see. But I think the thing to pay attention, most importantly, as this case proceeds forward, is what is the prosecution's theory going into this case, and how strong of a theory is that? Their theory is essentially that because he was so careless, because there were so many other cavalier attitudes towards the weapons, specifically Baldwin's use of weapons. There's video of him waving a weapon around as if it's a pointer. There's even suggestions that there have been misfirings of those weapons in the past, or that he had even fired that weapon, all with blanks, by the way, previously after it was announced that they had cut the scene. Is that enough to show that he was so cavalier and careless about his use of weapons that this was an event that was likely to happen? Problem is, I think everybody in first impression, views this as a tragic accident. From the very beginning, that's the way this has been described. No one is trying to say, even the prosecution, that he intended for this to happen. They're just saying he was so cavalier and careless that he should have known it was going to happen. But if I'm the defense, I have spent the last few months preparing for this trial by finding out how many times Alec Baldwin has ever been on set. How many of those hundreds of times, perhaps, has he been handed a weapon? And how many in any of those times was he ever expected that that weapon was loaded with a live round of ammunition? And I guarantee you that answer is absolutely zero. Of all of the hundreds, and I would love, if I were his defense attorneys, to come into court and say it was 1,232 times he was handed a weapon over his long career, and never was there ever a live round in there. How can you possibly say that he should have had any expectation that something was going to go wrong in this one instance? But again, you guys be the judge. I would much rather hear your thoughts on this. Do you think Alec Baldwin should go down for this, or do you think he's actually got a pretty good built-in defense? Please let us know in the comments. Before we dive into the other cases making headlines this week, happy 20th episode, everybody. Can you believe it? It has been 20 episodes now of Courtroom Confidential. And don't forget, by the way, that we are also a podcast. So please check out Courtroom Confidential wherever you get your podcasts, on Apple Podcasts, Spotify, Amazon Music. We are so encouraged by this growing Courtroom Confidential community. And I only ask this one thing. If you haven't already, please take the moment to go subscribe to this channel. And if you have, go bug a friend. Again, we are blown away by the response, and we look forward to continuing to provide you with even more content every week. All right, also making headlines this week, Wade Wilson, the Florida man convicted of killing 2 Cape Coral women, is one step closer to being sentenced to death for his crimes. Wilson was convicted on June 12th for the murders of Christine Melton and Diane Ruiz. On Wednesday, June 25th, the jury in Wilson's trial voted in favor of recommending the death penalty for each of the murders. Jurors who had the option of recommending life without parole or death voted 9-3 and 10-2 for death. Florida juries were required to vote unanimously for a death sentence recommendation until April of 2023, when Governor Ron DeSantis signed into law a bill allowing the jury to recommend death with as few as 8 votes. It will now be up to the judge to impose the death penalty during sentencing scheduled for July 23rd. At long last, a trial date has been set for Bryan Kohberger, the Idaho man charged in the deaths of 4 University of Idaho students who were killed more than a year and a half ago. During a hearing on Thursday, the judge, John Judge, yes, that's his name, Judge, set the expected 3-month trial for June of 2025. Prosecutors maintain that they will be able to link Kohberger, who was a graduate student at Washington State University, to the stabbings of 4 students using DNA found on a knife sheath at the scene, surveillance videos, and cell phone data. Prosecutors have said they will seek the death penalty if there is a conviction. According to a report by CNN, Robert Crimo III, the man accused of opening fire from a rooftop onto a 4th of July parade in Highland Park, Illinois, 2 years ago, killing 7 people and injuring dozens, backed out of a proposed plea deal in a dramatic court hearing Wednesday. As court began, prosecutors said they and Crimo had agreed to a deal in which Crimo would plead guilty to 7 murder counts and 48 counts of aggravated battery, 1 for each named victim in the indictment. In exchange, he agreed to be sentenced to natural life in prison, and the rest of the charges would be dismissed. The judge then asked Crimo, who was brought into the room in a wheelchair, whether he accepted the plea deal, but he did not respond. His attorneys asked the court for a recess to discuss the deal with him further, and they then left the courtroom. When they returned, the judge again asked Crimo whether he wished to go forward with the plea deal, and he said no. The judge then tentatively set a trial for February 25th of 2025. When she last appeared in court on June 7th, Sarah Boone brought a 58-page letter for the judge in the case. At that time, Boone said that the letter expressed her continuing frustrations with her 8th attorney, Patricia Cashman, who filed a motion seeking to withdraw days later. The letter includes more than a dozen pages of legal definitions and excerpts from the Declaration of Independence, the Florida Rules of Criminal Procedure, and the Florida Constitution. The letter is largely focused on Cashman, who Boone accuses of withholding elements of her case. The letter is closed with Boone's signature, a heart, a note saying confused cat meme, yes, thank you. No hearing has been scheduled to address Cashman's request to withdraw. Courtney Clenney, a Miami OnlyFans model charged with murdering her boyfriend in 2022, appeared in court on Wednesday, where a judge ruled to exclude a key piece of evidence in the case. Judge Laura Cruz determined that the Miami-Dade prosecutor violated attorney-client privilege by accessing private Clenney family conversations with their attorneys. Earlier this year, prosecutors also charged Clenney's parents, along with their daughter, for allegedly breaking into the victim's laptop. State's attorneys had accessed Clenney's father's iCloud account, where investigators found messages indicating that the family was working with defense attorneys to guess passwords to access the laptop after her boyfriend's death. They eventually succeeded in gaining access. As a result of the ruling, defense attorneys are now requesting that the Miami-Dade State's Attorney's Office recuse themselves from the Clenney case. Clenney remains behind bars while she awaits trial. Before we get to what's on the docket for next week, I wanted to take this time to thank you all so sincerely for your support. The love from this growing Courtroom Confidential community has been absolutely amazing. We would like to give a special shout out to Susie's Desktop for the wonderful review on Apple Podcasts, and to Jody Arrington and CJ in LA for their kind words on YouTube. Keep them coming, folks. We always highly appreciate your feedback. All right, on the docket for next week, Colorado dentist James Craig will be in court July 2nd for a case management conference hearing. Craig is accused of killing his wife in 2023 by poisoning her protein shakes. Lori Vallow Daybell, who is facing 2 conspiracy to commit murder charges in Maricopa County, Arizona, will be in court on July 1st and 2nd for status conferences. A hearing that was set for June 25th on who is responsible for leaking a supposedly private conversation between Judge Earl Glanville and key prosecution witnesses has been postponed until July 3rd. Glanville has ordered Kenneth Copeland and his stand-in attorney to a hearing to determine why either of them should be held in contempt for disclosing an ex-parte conversation to Young Thug's attorney Bryan Steele on June 10th. Glanville is also ordering anyone else who was in attendance during that conversation to appear. All right, that is it for us this week, folks. I am your host, Joshua Ritter. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. Thank you again for joining me. Have a great weekend. I will see you again next week for another episode of Courtroom Confidential.